I want you to know I'm calling in from a very scenic rest area. Mr. Vice President,
as is Commissioner O'Donnell, and I believe Commissioner Pinochi will be joining us. Lucas Hamilton will be advising the commission as we proceed. This is the time set for the oral argument in docket 2019.06.034 regarding CBC's objection to Northwestern's compliance filing on remand. The purpose of today's argument is to receive arguments from CBC and Northwestern regarding CBC's objection to Northwestern's most recent compliance filing. I note for the record that this argument is not being transcribed. However, it is being recorded and live streamed on the commission website. To ensure that the commissioners and those participating remotely can hear your arguments, please speak into the microphones. They are recording when the blue light is illuminated at the base. I'd like to move now to introduction of counsel. Please state your name for the record and who you represent, Mr. Uda.
Good afternoon, Mr. Chairman.
Works for me.
Okay. My name is Michael Uda, and I'm here on behalf of Caithness Beaver Creek Projects 1 and 4.
Thank you.
Good afternoon. My name is Shannon Heim. I'm the Director of Regulatory Corporate Counsel for Northwestern Energy.
Thank you. We'll now provide an opportunity for public comment. Is there anyone in the room or online who would like to provide public comment on this proceeding? If so, please identify yourself. Anyone in the room who wishes to make public comment? Anyone online? Okay, well, hearing none, then we will proceed to the oral argument portion. Now move to the argument. To ensure we have adequate time for questioning, we will limit each party to 30 minutes for their argument. CBC will go first, with Northwestern responding, and CBC can reply if it reserves time to do so. Commissioners, you can, or no, you can't. I'm going to ask that commissioners hold their questions until comments are completed from either party, at which point we then will let commissioners have all of their questions posed and answered. We will begin with CBC. Mr. Uda, you have your client's objection. We have your client's objection to Northwestern's compliance filing. I believe it would be most helpful to us if you would address in as much detail as you can the difference between Northwestern's current compliance filing and the compliance filing you believe Northwestern should have filed with that note. If you would please proceed, Mr. Uda.
Thank you, Mr. Chairman, members of the commission and staff. I just want to start off by reminding the commission of the procedural process that got us to this point. So the remand procedure was embodied in order number 7680G. That order, which was agreed to by all parties, gave Northwestern until July 26th of 2022 to do their compliance filing. There were specifics required in it, but I don't think those will be relevant to our discussion today. And then the next deadline, again agreed to by all the parties, was an August 5th, 2022 deadline for any party to file objections to Northwestern's compliance filing. On August 3rd, 2 days early, CBC filed its objection to Northwestern's compliance filing. Then the next deadline was August 15th for all parties to file responses to any objections. We did not receive any response to our objection. And at one point on August 17th, Mr. Hamilton, who sits at this point to the immediate right of the chair, sent an email to Northwestern. The email basically said, hey, were you guys going to file a response? Or did I miss something? Ms. Heim, who is present here today's response was, you didn't miss a filing from us. The arguments raised by CBC in their objection were already addressed in the litigation. Shannon, we took that as no response. Keep in mind that the district court rule is that if a party files a motion and there is no response, that argument is presumed to be well taken. Northwestern to this date has not filed a response. This is the first time I would hear any response to our objection, which is after our meaningful opportunity to file a reply, which was also set up in the agreed upon procedural schedule. This is a situation where somebody doesn't complete a final exam and the teacher, the professor says, oh, that's okay. You can do an oral exam after the deadline. Now, leaving aside whether any of this is consistent with due process, it's not fair. We would have had a chance to respond to any objection that they made in our reply, and we did not get that opportunity. Instead, we're being afforded an oral argument opportunity in response to arguments we've never heard or seen before. And Ms. Heim's response that the arguments raised by CBC in their objection were already addressed in the litigation, I would say is facetious at best, because we did not even see their compliance filing during the quote litigation. We did not even know that there was a defect in the compliance filing until we received it. And we immediately made our objection known. And there was no response forthcoming from Northwestern. So my first question to the commission is, why am I even here today? You could have simply ruled on the basis of our request for an order and foregone this entire procedure. Now, maybe you wanted to let Northwestern have another bite at the apple. I don't know. But it seems to me that that's a very unfair procedure to CBC when we complied with all the rules and Northwestern did not. Moving to the substance of the matter. Let's be clear about what the district court said. The district court was very clear about what it expected the commission to do. And if you look at the order on page 7, the court starts on line 5. Northwestern concedes the commission incorrectly used data from July of 2019. Northwestern suggests the court should remedy this by remanding the trading days issue back to the commission to, quote, forecast curves using the 15-day periods before CBC incurred LEO, which would be January and April of 2019. At that point, she cites to Northwestern's response brief on page 12. However, this is the court again, Northwestern's solution requires the commission to reopen the administrative record, something the court seeks to prevent. The court therefore orders the commission to calculate avoided costs using the 11 trading days from CBC already contained in the record. The court concludes that analyzing the April 2019 trading days offered by CBC is the approach most consistent with this court's order and Montana law. The 11 trading days already contained in the record will also provide parties with more immediate finality by not reopening the record. For these reasons, the court orders the commission to adopt CBC's 11 trading days approach. To be clear, the reason we filed the objection is that the implication of the court's order, the clear implication of the court's order is that the only forward curve in the record was the one offered by CBC. You couldn't use Northwestern's because it violated the court's order. So we had to use CBC's. What Mr. Bobineau did, and the error that was committed, is he created an entirely new forward curve, which is what the court's order expressly says not to do. But nonetheless, that's what he did, and that's why we filed an objection. It's that clear. You can either be in compliance with the court's order or you're not, but you can't be both fish or fowl. If you allow an introduction of a new forward curve in this record, you will be in violation of the court's order. It's that simple. And I believe that's all I have for now. I will reserve the rest of my time to respond to any argument made by my learned opposing counsel.
Thank you. Thank you, Mr. Uda. At this time, do commissioners have any questions for Mr. Uda? President Brown?
I'll reserve until the completion of Northwestern Energy's presentation, Mr. Chair.
Thank you, Mr. President. Commissioner Fielder, anything for Mr. Uda?
Not at this time. Thank you.
You gentlemen?
Thank you, Mr. Chairman. Just a question. You raised the thing about the final exam. Comparing these two statements, if the professor wanted to waive the final exam because the questions have already been answered previously in a previous test, that would be sufficient, wouldn't it?
Mr. Chairman, Commissioner O'Donnell, my analogy may be imperfect. The difference would be, of course, that a teacher or a professor in a classroom setting has a great deal of latitude. You do not have that same latitude. You are subject to a specific set of statutes, rules, and regulations. And in this case, all due process was afforded to Northwestern. The only party here who might have a complaint about due process would be us. Can you imagine the situation where a professor said, okay, well, I'll waive the final exam for this guy, but not for everybody else? Would they have a legitimate complaint? I would think so.
Follow up, please. No, a great point. And I didn't mean to belabor that type of thing. But it seems to me, not being an attorney, that I have heard on occasion a response being asked and answered. And it would seem to me that I interpreted Ms. Himes' response that it's already been covered as asked and answered type of thing, so that that your objection had already been answered on the record. That was just my understanding of that. So I just wanted to.
Do you want me to respond?
If you wish.
Okay, so what Ms. Himes said cannot be taken seriously because we did not identify the new forward curve until after the compliance filing for the simple reason that it did not exist. Thus, whatever prior argumentation Northwestern made could not have addressed that issue. Moreover, and this is an important point, she didn't even bother to say where. It is incumbent upon litigants to identify the basis for their arguments. That was not done.
Mr. Hamilton, have you got questions for Mr. Uda?
I do. Thank you, Mr. Chairman. Mr. Uda, I appreciate the points that you've made. I would like to try, if we can here, clarify what the difference is between the market curve that Northwestern submitted and the market curve that you would like to see Northwestern submit. What specifically is different?
Well, as I indicated in my opening remarks, the main difference is that the forward curve that CBC created using the 11 days is already in the record, and Mr. Bobineau's is not.
Okay, so as I understand it, Mr. Uda, that forward curve would use 11 trading days that CBC offered, right?
Right.
And those are days from March and April of 2019.
I believe that's right. I don't remember if they were all in April. Some might have leaked into March, but they were generally in April. Yes.
Gotcha. And so that's the information that we'll use, Northwestern should be using in its compliance filing to establish the forward market curve. For 2 years, there's going to be market forwards, right?
Well, I mean, I think the point is, what forwards are you talking about?
Yeah.
What we're talking about here is a brand new forward curve that no one has seen before after the court had already ordered the record closed.
So, okay, help me understand that though. The market forwards that we're talking about here should be averaged from the 11 trading days that CBC submitted, correct?
It should be using an average of the 11 trading days from April or whenever it was. But the forward curve already exists in the record. There doesn't have to be anything else done.
Okay, so when does that forward curve begin?
2 years after, I believe 2 years after the average from April, from the date of the LEO.
Okay. From, sorry, could you clarify when the date of the LEO
Sorry,
is?
the date of the LEO was June 12th, I think, of
Okay.
2019.
So we have the trading data in evidence from CBC. And we begin using that trading data in the market forward period that it establishes in June of 2019,
Yes, from the date of the LEO.
from the date of the LEO.
Yeah, so you would go out 2 years from that. You wouldn't go out 2 years from April because that wouldn't be the date of the LEO.
Okay, so then under that, the forward market period should end in May of 2021.
I'm not sure exactly,
Okay.
whatever's in the record.
It has to end after 2 years, though. Is that correct?
I don't think it has to end because the truth of the matter is that the court said, use these 11 trading days, and the only forward curve in the record is the one submitted by CBC.
I agree with you there, Mr. Uda, that we use the 11 trading days in the forward market period that it establishes, but did the district court direct the commission to end that after 2 years?
The district court did not. What the district court said is don't accept any new evidence.
In the first petition for judicial review, didn't the district court's order direct the commission to use a 2-year market forward period?
I don't recall. I didn't prepare for that, but I mean, if you say it's true, I'll accept it. I mean, but we've had an order since then, and the order could not be clearer that you're not supposed to reopen the evidentiary record.
When should Northwestern, in its compliance filing, end the forward market period and begin escalating at Henry Hub?
What Northwestern should have done is use the forward curve that was already in the record instead of creating a new one.
Okay. In the commission's first order following the first remand from the first petition for judicial review, would you agree with me that the commission had used, I think it was 6 years and then backed off to 4 years in its final order in this case, the forward market periods?
I don't recall if that was this case or the CBC 1 and 4 case.
That's fair. If we go back to that order and the order tells us that we had to shrink that to 2 years, is that 2 years of market forward in the record?
I believe that in the forward curve that we advocated for and that is currently in the record, there is at least 2 years of data in there.
Okay. So, and I appreciate that, Mr. Uda. Doesn't that mean the commission, if the district court said ended after 2 years, it has to end depending on when you start, 2 years after that start date?
Well, if that's what the district court said, and that wasn't modified at all by the final order that we just got, I would say that's correct.
Okay. So let's.
But can I just
absolutely.
say something? I don't think any of that is necessary. There is a forward curve already in the record. You don't need to do any of that. What you just need to do is direct Northwestern to run it through the workbook and calculate a new avoided cost, which is not what they did.
I understand, I think where you're coming from there, Mr. Uda, but if we were to use a period longer than 2 years, when the district court told us we could only use 2 years, we would be violating the district court's order, wouldn't we?
If you used a period longer than 2 years and there wasn't any other reason to use a longer period, you could be in violation of the court's order. I don't want to debate hypotheticals. I mean, the truth of the matter is I don't really know for sure, comparing this order to the other order, what exactly was said. But what I do know is that there is already a forward curve in the record, and that if you start monkeying around with it, you will be introducing a new forward curve and reopening the record and raising another issue about appeal. And I don't think we should go there.
Okay. You've mentioned it I understand. I think you even read from the district court's order that talked about reopening the record. And in that, the judge talks about seeking not to reopen the administrative record. Do you interpret that to mean not accepting, additional filings in what we would file, what the commission files as an administrative record in front of the district court? Or is the judge referring to not reopening the evidentiary record, having to have a hearing, take testimony, that sort of thing?
I would argue for the former instead of the latter.
Okay.
She could not have been clearer. She didn't want you monkeying around with the record. The only evidence in the record, the forward curve that exists, is the only one that's valid.
When if Northwestern submits a new compliance filing, as you've asked the commission to order Northwestern to do, isn't that in addition to the administrative record?
What that would be is basically a new calculation based on the court's order using 11 days in the existing forward curve. That would be in compliance with the law. It would not be adding new evidence to the record because the evidence already exists. All you'd be doing is doing the scrivener's job of tallying things up, which is what should have been done here.
Okay, so if the evidence is in the record and we're conducting the new calculation, that resulting filing.
We're not doing a new calculation. We're simply taking it and running it through to get the avoided cost and then putting it in the monthly workbook. That's all we're doing. It's like I said, it's a functionary task. It's a scrivener's task. It's not a task of creating an entirely new forward curve.
Okay. I agree with you. We're not coming up with a new method of calculating anything here, right? We're taking the evidence that was in the record, we're applying the district court's order, and we're getting to the end result. And that end result filing is not in addition to the administrative record that would violate the court's order.
I'm not exactly sure the implication of everything you're saying. I'm just going to tell you again what I believe, which is I believe is you have a forward curve in the record, and what Northwestern should have done is use that forward curve to calculate avoided costs, which they did not do.
Okay. All right. So if the court instructed the commission to use only 2 years in the first order on remand, is it your position that the second order on remand would allow us to use a different market forward period if that was what CBC had originally requested?
Well, I mean, some of this is clearly a matter of trying to figure out exactly what the court's intent was. And I mean, I can't necessarily get into her mind and figure out exactly what she thought. But what I can tell you is she was clear as she could be that we weren't supposed to be creating new forward curves.
Right. Right. Okay.
There's already a forward curve in the record. It can simply be used to calculate the avoided cost. I mean, I'm not sure why we're even here. Again, my point was they didn't file a response, nor did they give us an opportunity to file a reply. Yet we're here today having to deal with these questions from the commission. I mean, I failed to understand the point of all this because there's already a forward curve in the record that could be used. I don't even know why you're worried about it.
I appreciate where you're coming from there, Mr. Uda, in particular about Northwestern's lack of a response to your objection. Evidently, though, there is some confusion about what the proper compliance filing should be, else Northwestern would have done exactly what you've proposed from the outset. So if Northwestern is going to be ordered to submit a new compliance filing, I think it's prudent for the commission to be as granular as possible to get exactly what you expect that compliance filing to include, so that there is no possible doubt.
Right. I mean, I do think that, you know, being more specific, I really hate the term granularity. People throw that in all the time, and it's a mean nothing word. But I think the more specific you can be, yeah, the better. But let me just say this. It is not your job, nor my job, to tell Northwestern what to do. It's their job and their lawyers to figure out what to do. Why are we trying to bail them out?
Okay, Mr. Uda, I appreciate your perspective there. I don't think that the commission is trying to bail anybody out here. We're trying to get this.
Mr. Chairman, this is President Brown. I take great umbrage at Mr. Uda's assertion that the commission is somehow trying to bail out Northwestern Energy. I would direct Mr. Uda to remain professional and respectful of the commission moving forward, Mr. Chairman.
Thank you, President Brown. Duly noted, I assume, Mr. Uda.
I got no problem with that.
Thank you.
I think I'm done with my questions here, Mr. Uda. I'd just like to make sure that I can recap what it is the commission should be doing here, right? The commission should use CBC's 11 trading days.
Yes.
From those 11 trading days, the commission should map out 2 years of market forward period.
That's not what I said.
Okay. We should do that if the district court told us to do that.
You should do that if you believe that's what the district court required.
Okay. And then after that period, we apply the Henry Hub natural gas escalation rate.
Yes.
And
For
that
the length of the contract.
for the length of the contract. And from there, the compliance filing, minus that part in the middle that there may be some interpretation about what the district court directed the
No,
commission
I
to
see.
do.
Again, I disagree. I mean, what I've been trying to explain to you is there's no reason to do that. There is already a forward curve in the record that can be used and relied upon.
I guess, Mr. Uda, can you confirm for me, yes or no, does that forward curve use 2 years of market forward period?
I don't recall exactly. I think it was 2 years. It may have been longer.
Okay, thank you. I think that's all I have.
Mr. Chairman,
Could I ask for a clarification here of council? Is this, is anybody stating that by limiting the term to 2 years, that invalidated the price curve that was submitted, and then it necessarily creates a different formula for making that curve?
Mr. Chairman, Commissioner O'Donnell, I don't want to put words into Mr. Uda's mouth. So if that's a question for Mr. Uda.
Well, no, I'm just saying is that Mr. Uda is saying that it's the curve that's on the record. What you were pointing out was that in the remand order number 1 is that we were limited to 2 years. Does that materially change any of the factors that went into the forward price curve that's on the record? Is therefore requiring a new price, new formulation?
Mr. Hamilton or Mr. Uda, either both. Mr.
I
Uda?
mean, this is what I would say about that. It's a good question, Commissioner O'Donnell. What I would say is typically the longer you use the price strip from mid-C, the lower the avoided cost is. So because you get to the escalation quicker, if you see what I'm saying. So like if you have 2 years and then you have, I don't know, I'm just throwing out a number, but 18 years of escalation, it typically would end up being a higher avoided cost than it would be if it was 4 years or 6 years. Okay, I don't really know what the effect here would be. I mean, we haven't run the numbers, but my entire point is there's already a curve in the evidentiary record. We should just use that because it's already there. We don't have to run 2 more years or do anything else.
President Brown, did you try and weigh in here a second ago? President Brown? Assume not then. All right. Thank you, Mr. Uda. I appreciate that. And now we will move to
Mr. President.
Mr. President, did you have a question for Mr. Uda?
I do. I'm having the mute issues here. So, Mr. Uda, I have a question that follows up from the line of questioning from Mr. Hamilton. I'm trying to understand, Mr. Uda, your argument that seems to impute Rule 2 of the Uniform District Court rules into our proceedings. It seems your argument is that we don't have authority to either hold today's hearing or we don't have any authority now to deny your objection based on Rule 2 of the Uniform District Court rules. Is that what I'm understanding? Please clarify.
Is he Mr. President now? Oh, okay. Mr. President, no, on both counts. I'm not saying the commission doesn't have the authority to deny the relief that we've requested, nor am I saying that Northwestern's failure to respond is fatal. What I'm suggesting is not a matter of preclusion of Northwestern to having a response, but rather they've never filed anything up until this point. And yet here we are today having oral argument to allow them to explain themselves. And, you know, I have my doubts that if my clients were in a similar situation, the same relief would be afforded. And I'm saying is it's not fair.
Follow up, Mr. Chair.
Follow up, Mr. President.
Mr. Uda, does the commission have an independent obligation to correctly apply and enforce the district court's order, regardless of what any party does in this proceeding?
That would be correct. But it's also the case that the commission is obligated to follow the directions given by the district court.
I don't disagree with your premise, Mr. Uda. Perhaps this proceeding is designed so that the commission is following the purpose of the terms of the district court's order, and any allegation that you're making to the contrary, again, is not appreciated, Mr. Uda. No more questions, Mr. Vice President.
Thank you, Mr. President. Anything else from commissioners? Commissioner Fielder, anything?
Yes, Mr. Chairman.
Fielder.
Thank you. Mr. Uda, I think the primary purpose of today's hearing is to help us understand your objection. And I'm trying to ascertain when you assert that the forward market period ends and the natural gas escalation rate begins.
I'm sorry, were you finished?
Yes, that if we could get clarification on that, I think it would be very helpful. What is it that you're saying? As
What
far
I'm
as
saying is,
when that market period ends, the forward market period ends and the natural gas escalation rate begins.
Mr. Chairman, Mr. President, sorry. Commissioner Fielder, what I'm saying is you don't need to do anything because there's already a forward curve in the record. Whatever it is whatever it is. I don't know what it is. But I don't recall exactly the period of time. Keeping in mind two things. One, we didn't create it, Northwestern did, or at least people acting on behalf of Northwestern. I think in this case is Ascend. It's hard for you to remember who's actually doing these things these days, but I think it was Ascend. And the second issue is that from our perspective, we keep relitigating issues over and over and over again at considerable cost to my client. We don't have ratepayers to pay for that stuff. We just have to pay for it ourselves. So what we'd like to do is to see this proceeding come to an end. And we think it can happen if you just use the forward curve that was in the record that used the 11 trading days.
Mr. Chairman, I'll just offer a point of order since Mr. Uda seems a little bit
Commissioner
confused.
Fielder.
Thank you. Just to help Mr. Uda understand what the titles are. The person who's conducting the meeting is the chair. The president is always the president, regardless of whether he's in the chair or not. So today's chairman is Vice Chair Johnson.
Okay. Thank you.
Actually, Commissioner,
You're
the
welcome.
chairman today is Vice President Johnson.
Thank you.
All right, with that, we will move on to Northwestern, and Ms. Heim, it would be helpful to us if you would describe in as much detail as you can how Northwestern's filing complied with the court's order. So with that, the floor is yours.
Thank you very much. Good afternoon, Chairman Johnson, commissioners. Northwestern has likewise fully litigated this case before the commission and in the district court. We accept the outcome of all of the process that the parties have been through, and we submitted our compliance filing on July 26, 2022, reflecting the results of the second petition for judicial review. To be perfectly clear, we submitted our compliance filing what we believed we were required to do under all of the litigation that we've been through, all of the adjudication at the commission. We followed the rules and we stand on what we filed on that compliance filing. I appreciate the opportunity to talk through that and try to answer the questions that Mr. Uda clearly seems to still have. But we didn't offer a response because we thought one wasn't necessary because our compliance filing was complete. So I do want to be as specific as possible about what we did so that we're all on the same page. Northwestern staff, Michael Bobineau, who's actually on the phone, although oral argument's a little bit of an odd place to call in someone, but he is available if commissioners want to talk to him specifically, but Mr. Bobineau used CBC's 11 trading day average price strip. That was what was ordered by the court. That's what he used. And the EIA escalation per the directions. We began the escalation when we normally would when ordered to use a 2-year strip. So what that means is that we began that 11 trading day pricing strip on the month after the last price data was collected. So the way that the court ordered the 11 days to be calculated, it was completed in April. So then you start that price strip in May of 2019. So we ran that price strip for 2 years, which was what the district court required. And in May 2021, that's when the escalation began. And so we did not create new evidence for the record. This is consistent with commission precedent. This is how it's done. This is how we describe this process, consistent with our 2019 supply plan. I'm a little baffled by what the controversy really is, because in our view, we took what was required and we created a compliance filing. We are not seeking to reopen the record, did not seek to reopen the record through a compliance filing, but this is the natural outcome and completion of a docket, is us putting in our compliance filing. And we believe it's accurate and reflects what the commission expected from us and what the court ordered. With that, I'm available for questions.
Thank you, Ms. Heim. Questions from Commissioners, President Brown.
None. No questions.
Thank you, Mr. President. Commissioner Fielder.
No, I look forward to hearing Mr. Uda's response to that. Thank you.
Commissioner Pinochi, questions for Ms. Heim. Commissioner O'Donnell. Good. We thank you all now. Oh, you've got questions?
Just a couple, if you will.
Mr. Hamilton, I'm sorry.
Mr. Chairman, thank you, Ms. Heim. If the commission directs Northwestern to use CBC's compliance filing, is that clear what you should be doing? Or excuse me, I shouldn't say, let me rephrase that question. I screwed that up. Use CBC's forward market curve.
That is not clear to me exactly what we would do, but of course, I'm not the person who would have to generate that. My understanding is that you take the inputs and then you generate the compliance filing. You put it in the workbook and it spits out what the compliance filing contains. And so my understanding is lifting a price curve out of the administrative record would be unusual and not follow commission precedent. We look at the methodology and apply it, but I can't tell you honestly, Mr. Hamilton, if CBC's price curve actually differs at all from ours. My understanding is that the price curves themselves are what they are. It's just, when do you start that? When do you implement? And so, we, as I indicated, we started it in May 2019, which was the month after the 11-day trading curve data stopped, ran that for the 2 years ordered by the court and the commission, and then escalated from there.
For clarity's sake, when does your market forward period end?
I believe it ends in May of 21, right? Is that right?
Relying on you, Ms. Heim. Yeah,
That's always dangerous.
if you don't know that, that's a fine answer.
Well, the market forward is the 2 years, right? Because the trading days end in April of 2019, and then the market forwards begin in May of 19 and run 2 years until the end of May of 21. And then the escalation starts then in June of 21.
Thank you, Mr. Chairman. Nothing else.
All right, thank you, Ms. Heim. Mr. Uda, you may now proceed to respond with the time that you reserved.
I don't know if I have any time left after the commissioner questions, but I appreciate the opportunity to have this discussion. I think where the rubber hits the road is that regardless of how Northwestern calculated it, the two price curves are different. Okay, so you have one that's in the record that dictates a certain avoided cost estimate, and then you have Northwestern's, which did not exist until after the remand, which did not exist until after the commission ordered the compliance filing. Those two are different. So if you are relying on that, you are relying on record evidence that did not exist prior to them making their compliance filing. And that was the point that we made in our objection, is that you can't do this. You can't create new evidence after the close of the record. And however you want to characterize it, that forward curve is new. And if you're going to rely upon it, then by definition, it is evidence. So from my perspective, I think the main difference between what we want and what Northwestern wants is Northwestern wants the ability to calculate a new forward curve, which is what they did, which is why we objected. And we think the court's order is explicit about not reopening the record. And I think that's really all I have to say. Thank you for your time and attention. I appreciate the opportunity.
Thank you, Mr. Uda. President Brown, any questions for either of the parties?
None at this time, Mr. Chair.
Commissioner Fielder,
No, thank you.
Commissioner Pinocci, Commissioner O'Donnell, Mr. Hamilton, you're done. Well, with that, I want to thank council for taking the time and running through the arguments for us. We appreciate that. And for the record, it is 1:42 p.m. on the 13th of September, 2022, and this oral argument is adjourned.